So I think there is, it's a legitimate concern for everybody. Anybody that's working outside of their own relationships, that they're working with some sort of either raw data, third-party lead, or cold calls, it's going to be a concern for everybody. So
because the management and transparency is what's very important. So once you submit a referral, you're going to have your own Home Advantage account, and it's going to tell you where everything sits. So if you have 10 referrals that you've sent into the network, it's going to give you all 10 referrals. It's going to tell you every milestone that client is sitting in, whether they're touring homes, whether they're in escrow. And you now can manage through the Home Advantage application as far as what your pipeline looks like for the referrals that you've sent. And so it's pretty sophisticated, and it's all click of a button, guys.
Today, we're going to be talking about one of the easiest mistakes you can make that's also one of the most costly. We're going to be talking today about best practices dealing with and avoiding the penalties of the TCPA. And if you're like me, you probably heard the word TCPA and have no idea what that guy was talking about. And I learned what that word meant in a very hard way, in a very hard lesson. So here with me today, we've got a good attorney friend of mine, Bill Krzeski, who helped me personally and my company through a rough TCPA case. So Bill, if you don't mind, can you kind of start out and just let us know, let the audience know when they hear TCPA, what are we talking about?
Mike, first off, thanks for having me on today. And everything we talk about today, we have a pamphlet that we are happy to make available that has everything we talk about and outlined and our information if anybody needs any help. But getting right to your question, the TCPA is the Telephone Consumer Protection Act. It is a federal law that is designed to prevent spam texts and phone calls. And in this context, it applies to agents possibly contacting leads, potential clients, et cetera. And it has major liability concerns for real estate agents and brokerages all across the country. So regarding the TCPA, there's a federal equivalent and there's also state law equivalents as well. The federal statute applies to all real estate brokerages across the country. Doesn't matter if you're in Alabama, Arkansas, or Washington State, it applies to you. Now, there's also new legislation coming out that's applying to a number of states as well, meaning that brokerages in a number of states have to be, number one, federally compliant and state law compliant. So what we're here to talk about today is kind of the precise way it plays out. Real estate companies, obviously, they get leads. Where do those leads come from? You know better than I do, but primarily they come from lead generators, networking events, and client referrals. And some of those leads, they have emails, they have phone numbers, et cetera, et cetera. And then agents contact those phone numbers, whether it's a phone call or a text. Where it becomes a little bit tricky is when agents contact phone numbers that are on the federal Do-Not-Call Registry. Do you know what that is, Mike?
I found out the hard way what that is, but yes, I did find out what it is. And, personally, I'm not even on the do not call list. I never took it that seriously. And just like everybody else, I got the spam calls like everybody else, and you get upset and you think, hey, don't call me again. You tell people to take you off the list. And I found out, and I'm sure you're going to talk about it today, that there's people out there that specifically are targeting people that are hoping that they get the call because they're on the do not call list because the penalty is so stiff. So I learned what the do not call list was the hard way.
Yeah, and the Do-Not-Call list is essentially, for those that don't know, it's a database that's online that's very easy to use. In order to put your number on the Do-Not-Call list, all you have to do is go online, insert your number, and say, I don't want to be contacted. At any given moment, there's about 80 million phone numbers on that registry. And where the TCPA comes into play is when an agent contacts a lead whose number is on that registry without their prior express written consent. So when that happens, that constitutes a violation of the TCPA, which can range from a monetary penalty of $500 to $1,500 per violation. So
now, Phil, we're going to be talking about some exceptions to this too today, right? Like, let's say you've got a friend that referred you as an agent. They referred you somebody that was interested in buying a house, and that referral, of course, you're going to have to call that person. And if they're on the do not call list, I mean, it's probably going to be a different situation when they're asked to be contacted. They didn't give written consent, but they asked through a friend for that referral. That might be different then if, for say there's for sale by owner in the neighborhood that has a house for sale and an agent calls that person trying to convert them, they're not trying to, put a purchase agreement on that house, but they're converting them to a listing. That might be a different scenario between someone that's a referral versus someone that's a cold call versus somebody that's a paid lead. But this is something I think we'll probably talk about today too, that, that the names on the do not call list and how you interpret who you can and cannot call, the way we conduct business is going to kind of, you're going to have to take a look at that, how you conduct business. Are you working with referrals, leads, cold calls to really help determine who you can and cannot contact?
That's a great point, Mike. So a number of leads come from client referrals. That falls in what we call a business relationship exception.
Mm-hmm.
Numbers that we're talking about primarily are lead generated, meaning that there is no prior connection that comes from a third-party source. And it's those numbers that are really at issue here, because it's those numbers that fall into the TCPA realm. And more than that, they're also more likely to fall into the class certification issue, which we can talk about as well, or I can keep talking with the TCPA, Mike, whatever you prefer.
Yeah, one thing we will talk about today, obviously, is the difference between, an agent acting out or acting in a onesie twosie manner where they've contacted one or two people one or two times. That's different than if we're talking about an entire class certification, especially when you're talking about large teams or large brokerages. And we can do some case studies of what those large teams and brokerages, what they've been up against in settlement, because now we're talking about contacting people, thousands upon thousands of people, sometimes hundreds of times, when they're certifying that class for class action. That's a whole different set of consequence than one agent that's got 25 phone numbers that they've called and they violated a couple people on that do not call. Whole different circumstance.
Absolutely. And when we talk about the TCPA, the main danger is not the individual one-off text message to a number of do-not-call registry. It's the threat of a class action, right? I know there's people watching at home or from their offices, and they're wondering, what's a class action? Isn't that one of those things where I get a check for $2 in the mail because my dishwasher wasn't hot enough? Mm-hmm. In one sense, it is. But in this context, it's much worse than that because the TCPA affords a $500 per text message penalty. You hear stories of individuals receiving text messages or spam calls, whatever they may be, and those individuals may receive 30, 40, 50, 100 text messages, and their damages become quite significant. So this isn't what I would kind of call a gotcha class action in the sense of, we got you on a technicality. Maybe in that sense it is, but the damages are significant, and people, namely plaintiffs, have a direct incentive to bring these cases because they stand to gain a lot of money coming out of the real estate company's pocket.
So, I want to give one type of circumstance where these calls can be made. In my opinion, one of the more dangerous ones is when people purchase basically raw data. Let's say I was out there buying raw data, call it, 50,000 renters that I use a third-party company to buy names and phone numbers of these renters. And I just start dialing these renters, hoping, and I might even use a 2 or 3 line dialer. And I'm hoping that out of 50,000 people, I'm going to convert some people that are now renting that may want to buy a house soon in the future. Now, they haven't opted in for any lead registration. They haven't asked to be contacted. And now you're just, dialing people 2 to 3 numbers at a time on a dialer. And as people are picking up, you're having conversations. The people are not picking up. There's still a record that you've been calling. That's one of the more dangerous, and I don't want to get too far off topic, but as we're talking about different things that can play out here, that's one of the more dangerous areas I feel that you could be left for pretty major exposure.
100%. I think if there's one message that I'd like to have everyone take away today, it's that you need to know where your phone numbers are coming from. Mm-hmm. If they're coming from an open house, that's one thing. If they're coming from a friend or a family member, that's another. If they're coming from a lead generator, then you need to evaluate what is going into that consent form. If they're coming from some other source, you need to be very, very careful because that is prone to TCPA violations, whether you know it or not. I would advise highly against ever contacting anybody whose number you just found randomly or obtained from a third party that's not vetting their intakes.
Because Phil, we're going to talk about this today too, that there's actually serial plaintiffs, people that sit around and wait for these phone calls to come in just so they can contact the lawyer and start a class action case. I mean, there's literally a serial list out there that people can obtain because, and when I say serial list, I mean names of people that are serial plaintiffs that do this pretty much for a living, and attorneys that are targeting the real estate industry right now as we speak. And we're talking for large, 6, 7, 8 figure, even sometimes larger settlements is what they're searching for. So this is how big of a deal this can be. It's actually a pretty major threat. And some of the largest companies in the country right now, real estate brokerages, are dealing with this in pretty major, and we're talking about pretty major settlements in the 20, 30, $40 million range, big stuff. So, as we're talking about, knowing where your phone numbers come from, I think one thing, and this is what kind of got me tripped up, was when you're working with a third-party lead generator. And if you understand how lead registration forms work, the client or the consumer, the prospective buyer or seller is going to be asked to register on that site. And when they're asked to register, they have to fill in, their information, name, phone number, email address, and then at that point they're opting in. There's a basically a permission to be contacted. Now, in those terms and conditions, and what we believe as agents, and what we're taught to believe as agents, is those companies have done their research and they've vetted Do-Not-Call and TCPA law and practice, and they're keeping everybody safe. Everybody should be just fine if they're using a company that uses a good lead registration form. That doesn't always work out. It doesn't always pan out because some of these third-party companies don't keep their records long-term. So if something pops up years later, they may not be able to find the records, from years ago. What could have happened too is whoever registered on that site registered with a fake name and a fake phone number, and that fake phone number was then attached to somebody that is on the do not call list and even potentially a serial plaintiff. Right. Or another thing that could happen is some of these companies also are not really paying attention to the geofencing of where the registrations are coming from. So, I mean, if you have a common name like Joe Johnson, and you say, but Joe Johnson with this phone number did register right here, and they gave permission to call, but it's not really Joe Johnson. They're saying that they never gave the registration. Somebody gave a fake phone number, fake name. Some lead generators can actually pinpoint geofence or right where that phone number came from, that call came from, or that registration form came from. Others don't. So when you're really looking at the terms and conditions of these lead generators and understand what protections they have for their agents, and I don't know if there's a completely safe way to do this. I mean, if someone's coming after you, you're going to pay big money to defend yourself one way or the other. But best practices, it's probably a good idea that you really dig in with your lead generation companies, your third parties, and figure out what they've set up to try to set you up for success and safety in this.
100%. Yeah, I think the main thing you talked about here, Mike, are serial plaintiffs and serial plaintiff lawyers. Make no mistake about it. If you're a real estate company and you're getting your leads from an online generator, there's a good chance that you are a target.
Mm-hmm.
Some of these plaintiffs lawyers, they look for this on purpose. They look at the lead generators, they look at the terms and conditions language, they say, this lead generator may or may not be compliant. Here's why we think that. Going back to the idea of a serial plaintiff, there are individuals out there that will purposely try to entrap a real estate company or any kind of lead generation system. They'll have their phone number online. They'll submit a fake name, like you just said. And once they do that, there is almost an internal network between that plaintiff and other plaintiff lawyers who have basically a wash, rinse, repeat process to bring these cases. And once they're brought, that's when you have the real issue. And that's when you have the hard monetary costs coming out no matter what, And if I have a second message from this presentation, it's better to take the time now, spend the time, resources, and money to make sure you're compliant or do everything you can to get compliant, as opposed to finding out 6 months, a year, 2 years from now that, hey, you got busted. Now you got to pay me or another lawyer quite a lot of money to defend your case. This is what is it? An ounce of the cure or an ounce of prevention is worth more than a pound of the cure. That applies here. At the end of the day, as you know very well, Mike, when you're part of a lawsuit, it's not just the time and the money that goes into it. It's the emotional energy that you're spending on that lawsuit as opposed to growing your business. Whereas
Correct.
what we're talking about here is you take that time and energy and the resources now There's a less likelihood that you have to worry about it later.
So, in my own personal story with this, if I don't mind, I'll share that. So what happened with us is one of our agents contacted somebody. We've got, at the time, 700 agents operating out of 2 states at the time. Now we're in a few more states. We gave the lead. It's a lead we purchased. I want to say it was through Listens to Leads. That's where the lead originally came from. There was a lead registration form. And this is some of the things you have to think about too, because some of these leads you have to nurture for a long time. They might come in and opt in through that lead registration form. And then you're still following up a year, 2 years, 3 years later. Well, they may get on the do not call list. They might not have been on it when they first registered, but then later they've now gotten on it. Now the expectation is you don't call me, even though you've been communicating with them and they've been looking at your home search and other things you've been sending. But now the expectation is, hey, I'm on the do not call list now, and I have not given you permission since to call me. And now you've called me, and now I feel like there's a violation. So back to our story. That's kind of what happened here. Is we had somebody that was not on the do not call list. They opted in through Listens to Leads. Great company, love those guys. We do a ton of leads through Listens to Leads. Same with Ylopo, another company that we do a lot of leads with, and we have great success with it. So a couple of years later, as we're still nurturing that lead and following up, she was contacted. In between, now she got on the do not call list. Doesn't remember or claim not to remember that she ever registered in the first place. So she went forward and demanded payment. She was contacted 3 times, so she demanded payment. The agent said no. She was going after the agent first. When the agent said no, I'm not paying you. She brought an attorney in, and the attorney tried to sue the agent. Through conversation and deposition, they found out the lead didn't come from the agent. It came from us. It was a company sponsored lead. So now they've realized they have bigger and deeper pockets to go for. And this is when they started thinking about class action. Through the deposition of that initial agent, that agent, I could have thrown us under the bus, I guess you'd call it, but she made it sound like we've got a huge national, lead generation call center going on, and we're contacting millions of people, which is all, factually untrue. We're operating out of 2 states, and we work with a small group of agents, and we got a certain amount of leads. I think at the time it was 50,000. We purchased at that time, all through, legal, lead registration forms. But the deposition was done so poorly by the agent. It was a brand new agent, did not understand our systems. And that attorney grabbed on to what was said in that deposition and decided at that point, there's enough here. We're going to push for class certification. And we're going to try to get, a 7 or 8 figure settlement from this agency, Realty Group. By the time, after all the money we had to pay in legal defense, by the time we actually got to the point that we could prove that, she filled out the lead registration form, she opted in, she gave permission. By the time we got to that point, we were already 6-figure into legal defense. That's how fast and furious this rolls when it starts to roll. So there's some things that I think we could have done better in the first place. Right when the agent was getting pursued at TCPA, we should have jumped in as a company behind her right at the bat to figure out what was going on and throw some support behind that. We're talking about a few $100, and I thought she was just going to settle it and be done. I didn't even know it was our lead at first, right? We didn't even have good records of that lead because she left the company. This was one of the other mistakes that we made. She left the company after she was served, before she was served. When she was served, we kind of lost access to all of her stuff. So we were kind of blind at that point. We didn't even keep copies of it. After she left, we got rid of stuff. Why? Because as a broker, any of her stuff, her leads, we're not going to keep. We didn't want to ever give the impression that as a broker, we're keeping other people's data and other people's stuff in a CRM. Agents don't like that much, So here we erased everything and didn't have proper records. So that was a big mistake that we made. But by the time we were actually able to work with Listens to Leads, get the proper documentation we need, get to a point we could show the other side and start going through these outrageous claims. We had to untangle one claim after another. And by the time we actually untangled it and got to the bottom of it, we're talking 6-figure money that was out the door and about 18 months of time. And 2 different attorneys, if you remember. We brought you in second. Okay. So that was a lot of lessons in there because we did not have a real, disaster prevention plan with it. And that's where I think that, going through it now, we're going to focus on disaster prevention on something. When I say disaster, it truly is because it's disaster. If they go down a path of class action with you, that's a disaster. And as you said before, we got out lucky, 6-figure money spent, but that was lucky, very lucky for us.
Yeah, and we're very proud to say that. I think it was a painful process, but it had a happy end. I think another message that's I think I previously said, but I think it bears reiterating, is that the time to fix these issues is now. It's not 6 months into litigation. It's not when you get served with the class action lawsuit. The time is now, because also the TCPA has a 4-year statute of limitations. Mm-hmm. So if you fix it today and you don't get sued, or you never get sued, great. If you get sued 2 years from now, you just cut your damages in half. If you get sued 3 years from now, you cut your damages by 75%. So, it really is worth it to look into it and see where you have issues, if you have issues. I mean, hopefully the answer is you have no issues and you're good to go. But it's also good to know where you stand if you do have issues and how you can go about fixing that. There's a lot of ways to fix that. There's ways to kill class actions. There's ways to insert class action waivers. There's ways to institute arbitration. Those mechanisms protect you from a class action and turn your worst case scenario from $20 million settlement to $20,000. That's a big deal. And most plaintiff lawyers will know that, and they'll see that, and they'll say, okay, we got $20,000 on our best day. Let's just get done and let's go on to the next one. So again, Mike, thank you for sharing your story. And I think it's a great example. Unfortunately, it does have a happy ending. But, if we look at the little cheat sheet that I'll attach to this presentation, that didn't happen for Keller Williams. They ended up paying $40 million settlement. That didn't happen for eXp Realty. Have you heard of eXp Realty, Mike?
Oh yeah, we've heard of them. They're a big one out there. And I'll tell you the other thing too. And I was proud of this, and you guys helped us with this. And I'm pretty stubborn this way. We defeated the class action. We never had to settle. We never actually had to settle. We actually defeated class action. They failed to certify class, which led us to an exit out of it, very, very inexpensive for the actual settlement. However, the legal defense is where we spent all of our time, money, and effort. So that was cause for some sleepless nights, looking at the fact that we could have been into it for $1 million, $1.5 million, $2 million. Could have been, who knows what that would have ended up at by the time it was all over with. So, on something that we didn't even do, because, we do, as a company, we do things pretty well. Our systems are pretty tight. There's a few mistakes we made, as I mentioned. Going forward, I'd like to kind of, suggest some things for others that maybe they could have done better than we did. But, we were cognizant of TCPA since day one. And because of that, I think that, we fared well in the end, I'll say.
Yeah, and I think it also bears mentioning that the agent that did send the text messages sent 2 text messages and left 1 voice.
Right.
This is a public record. I have no issue talking about this. And it wasn't, hey, you got to buy this house immediately. It was, hi, my name is X, and I'd like to see if you're still interested in buying a house. Yep. And frankly, I mean, no disrespect towards the agent, but I think the second text message was essentially a cut and paste job by accident. The first text. Right. There is no bad actor here. There is nothing no malicious intent here. But the road to class action now, for lack of better phrasing, is paved with good intentions in the TCPA context.
Even if you're thinking, I'm a solo agent here. I do have some leads I buy. Am I really going to be targeted for class action? I probably do 20 transactions a year. I don't have that big of a database. And it's true, you're probably not going to be subject to the same class action, threats that maybe your broker would if your broker is running, $50 million or $100 million a year, GCI organization or bigger, right? So the larger the organization that you're tied to, that organization itself might have a threat. And you might think to yourself, well, who cares? Let them deal with it. Not my problem. And they have E&O, but E&O oftentimes doesn't cover TCPA. It's right in the riders. In many cases, it's not going to get covered. And if your organization goes down, so does everybody else in it. So it actually is a threat to everybody. That's why it's so important. And teams too. I think, teams of 4, 5, 6, 10 real estate agents, especially if they're producing and they invest in leads, there is the threat that they're going to get tied in. Even if it's not class action, you could still be talking $20,000, $30,000, $40,000 of damages owed, even if it's not class action. That adds up, and nobody wants to pay that. So that's not even talking about the legal fees. So I think there is, it's a legitimate concern for everybody. Anybody that's working outside of their own relationships, that they're working with some sort of either raw data, third-party lead, or cold calls, it's going to be a concern for everybody. So you mentioned the EXP and Keller, and I think Coldwell Banker had a big one that they were dealing with as well. But do you want to kind of share what those settlements look like?
Yeah, I'd be happy to. So, and just to bring up one other topic that you brought up is that the agency theory applies. And that means if you have one rogue agent that veers off the TCPA path, your entire brokerage is potentially liable for that agent's actions.
Mm-hmm.
So it's not like, if agent Y did this, we disavow him or her. It doesn't work that way. Essentially, if you're flying under the Realty Group banner or the Coldwell Banker banner, you're most likely going to be held liable as an agency, which, and then what that also does is it opens up the door to see what other agents are doing. And if you have multiple agents doing things that they shouldn't be doing, you got a real problem on your hands.
Mm-hmm.
But that's upon Keller Williams and EXP. I mean, Keller Williams is, obviously, I don't know the industry as well as you do, Mike, but one of the biggest real estate brokerages in the country. You'd think that they'd be buttoned up through and through, but they ended up paying $40 million in a settlement. And what the legal fees are, I don't know, but I venture to say they're probably in the 7-figure range, or at least 6 figures, all said and done. EXP, obviously another major brokerage, ended up paying about almost $27 million. And then two other real estate and real estate affiliated companies are Realology Holdings Corp. You heard of them, Mike?
Yep.
And Mojo Dialer, which I know is, I believe, a dialer.
Yes, Mojo is what they usually use for the 3-line dialers, one of the most popular in the industry. Realogy, which is now called Anywhere, they've rebranded their name. It's a holding company that owns Coldwell Banker, Better Homes and Gardens, and a whole bunch of other brands. So they're really, really big, and they got nailed too. What was their settlement again? Do you remember?
So actually, they haven't settled their case yet, but they have a case certified against them.
That's why I couldn't remember it.
They may win that case, but I'll tell you right now, you don't want to be in that position.
No,
because that means that every single spam text message or phone call or dial, whatever it may be, is potentially a $500 penalty against you. So, I mean, you can only imagine how many calls Mojo Dialing has made. That's a very bad position to be in.
Yeah.
It fortunately didn't happen for you, Mike. We're very happy and proud of that fact. But if it had, we'd be talking. This story would not have a happy end. I can say that.
Not at all. So let's talk, because I think you were also going to say, how do we advise? Obviously, agents, especially when you're running brokerages and teams that rely on feeding their agents opportunity. We're going to have to call leads. We are going to have to, create opportunity for our agents. And a lot of times that's going to be some sort of lead generation system outside of friends and family and sphere of influence. Oh, by the way, we have a question here too. We usually save these for the end, but I like this question. Did the complainant pay for your legal fees at the end? And the answer is no. And believe me, Phil can tell you this. That's just sort of my personality. I wanted to go after them so hard because a lot of the claims were just so false. They were just factually untrue, and they had no basis for them. But they just threw these massive claims out there that we had to continue to keep untangling. And yes, I wanted to go after the legal fees because they were just outrageous. And I'll let the attorney actually answer how that works. But the answer from my perspective, nope, we didn't get to do that.
No, and look, most courts across the country apply. Most, if not all, courts apply what's called the American rule. You pay your own fees, win or lose, and that certainly applies in the TCPA context. There is fortunately no fee shifting provision for the prevailing party for the plaintiff, which is a good thing, but there is no fee recovery provision for the defendant if they win. It's just not a reality. Now, going one step further, the person that sues you probably does not have the money to pay your legal fees. Usually there's somebody that is not a high income earner. We're talking generalities here. That's not always the case, but if you rack up $50,000 in legal fees, which in a federal class action case is not. I mean that's probably the first 20% to maybe 30% of the case. I mean. That's pretty much before discovery, before the heavy lifting begins. They're not going to be able to pay that money, and no court's going to make them pay that money either.
Unfortunately, this is true. I learned the hard way. I must have asked you that 20 different times. Every time I had to check redo the retainer. You're like, we got to re-up the retainer again. I'm like, how do we go after these guys with legal fees? So anyway, Phil, let's talk about, since people have to, I mean, in this business, we have to, if we're providing leads and opportunity for agents, we have to make these calls. How do we keep ourselves, I can't say safe. I mean, no matter what you do, right or wrong, if you get a hold of somebody that is, a serial plaintiff and they're tied to a serial attorney and they've got this system, you can get pulled into it. The question is, how well prepared for a defense are you right off the bat? What's sort of some of the best practices you can recommend?
So in this context, let's assume all numbers come from a lead generator.
Okay. Yeah.
You can do it. Look, you guys pay these lead generators a lot of money. They're good at what they do. They make you a lot of money. But one thing that you can insist upon with these leads that are created is to make sure they're TCPA compliant. And how do you do that? If you go on a lot of these lead generators, there's a terms and conditions provision that applies to each submission. If there isn't, you should get one immediately, but most of them probably have. In that regard, what you need to do, and frankly, this is a point where I suggest the lawyer, is to make sure that that language is TCPA compliant, meaning that it is language that is acceptable under the TCPA to contact. And what that means is that they give you prior express written consent to be contacted. I personally, and again, this is an informational presentation, not legal advice, but I would almost even include additional language that say, this applies even if I put my number on the Do-Not-Call Registry. Meaning that the only way I can revoke it is by calling you directly and saying, hey, I revoke it, something to that effect. Probably a little bit more specific than that, but that's the general idea. The second thing that we always advise everybody is make sure that even if you're scared that there may be a TCPA violation, which, as Mike said, there's not one cure, there's not a cure-all remedy for these situations, is to institute an arbitration provision or a class action waiver. What those mechanisms do is they prevent one plaintiff from being a plaintiff on behalf of everybody and limit it to just that one plaintiff. Arbitration is pretty common in this day and age. I mean, I venture to say most of your brokerages have an arbitration agreement provision in place. Typically you want to keep disputes out of course. You want to keep them in arbitration. At the same time, sometimes there's a benefit to keeping it in court, but waiving the class action mechanism and then leaving it outside of arbitration, because typically you have to pay for the cost of arbitration, which are not cheap either. So those are kind of my first two ideas that to run by you, whether it's me or one of your lawyers that you use. Figure out what that looks like and talk to them and get some advice on that. Because if you do option A or option B, you're in a better position than most, I think.
And I don't think it's a bad idea either when you're working with a lead generation company to really dig into, what their system is when a TCPA claim comes against them or one of their clients. To walk me through what happens when one of your clients gets a claim. How prepared are you to help step in, to help us out here? Because that was one thing that I don't think we had, the right footing early on. And like I said, we had some gaps in our records on this particular lead. Getting it from the lead generator, we learned that some of their records were out of date because they only kept them for so long. So really understanding their systems and seeing how often they get these cases. Do they come beside you to help defend it? What do they do when they get the call with you panicking, saying, I'm getting served and they're going to try to certify a class on me. I need your help. That to me would have been an important question going forward with anybody that we sign up with.
Absolutely. So, for every submission form, there should be an electronic record of that. It should go back at least 4 years, if not longer. Mm-hmm. And so that, if you do get sued, you can call your lead generator and say, hey, John Doe submitted a consent form. I think they did. Can you run their name? And if you catch their name, can you prove to me that they consented? And if you have that information, that can make or break your case. If you have a hard time getting that information, that can be a serious issue. And if you don't have that information, even if they did consent at one point and you can't prove that, you got a problem.
Or if the company themselves doesn't want to get involved and doesn't want to help you obtain those records, which I've heard of that before. So having that conversation up front of what happens. When we come to you and we've got a claim, what's your system? What's your workflow with this? That's probably a good question. It's one of the best practices I would recommend going forward. If we ever sign up with more lead generators, that's what we're asking.
Yeah, 100%. And look, you pay them. I look at that as part of their job to provide to you.
Yep. And I think we all assume they're going to, have the records you need. They're TCPA compliant. They know what they're doing in this arena. They've done it 100 times, but that's an assumption. Like, I think you actually have to have the conversation and see how often they get a claim. What the results were the last few that they've had. What do they do in support of the client? Do we really need to subpoena their records? Are they going to, willfully hand them over? It's things of that nature that you want to determine early on. And another thing too is make sure that you don't erase your own records. Make sure that you're not exporting your data out of a CRM, and then just erasing it. That's what we were doing on older stuff. We didn't even think about it. And again, we had agents that would leave and we just got rid of any record of their stuff because we didn't want to ever be accused of stealing their leads. Well, we could have come up with a different system that they still felt good about, that we'd have access to records if we needed it.
Right. And look, if you get sued and you delete agents' contact information when they're leaving, then you got different issues because then you're not pursuing evidence either.
Yep.
We didn't see that issue in your case, thankfully, but I could see somebody making that mistake very easily, and then you're causing yourself way more issues than you need to have.
Yep, absolutely. So I know we're kind of getting at the top of the hour here. Do we have any questions from the audience? Number one, and Phil, do you have any final thoughts as we're getting wrapped up here?
Yeah. So before we take any questions, if there are any, I think it makes sense for everybody, to take a step back and look at their own practices. The ideas that I have to kind of minimize your risk, even if it's just you yourself, is number one, scrub your phone numbers with the DNC registry. See what numbers are on the DNC registry and make sure you have the consent forms for those individuals. That technology is out there. I don't think it's terribly expensive. Do a little bit of research, do a little bit of investigation. If you want to do a sampling, that's one good step in the right direction. Number two is tell your people about the TCPA. Like I said, we got this little cheat sheet that we're going to attach to this presentation one way or the other. Talk to your people about it so that they're aware. I mean, look, at the end of the day, it's probably not you who's going to commit the TCPA violation. It's somebody that works for your company that will.
Yeah.
And if they're aware of that and they know about that, then they're less likely to commit that TCPA violation. And the other kind of piece of advice that I have is also look to see who's told you to stop contacting. Audit the number of revocations you get from people, if any, that say don't contact me anymore. Because if you have that, then you need to block those numbers off immediately.
100%. That's a great point, because a lot of times we hear from leads that they have to keep on telling people to stop calling. So I think some of this can be handled. Not everyone that you violate is going to be a serial plaintiff, right? So sometimes you can diffuse this very easily. If someone's telling you, hey, I'm on the do-not-call list, I don't want to hear from you anymore, take them off. Don't call them anymore, right? And the way that you handle it when they first let you know that you violated the TCPA, you can arm up and knuckle up or ignore them, thinking they're going to go away. But the way you handle that, thinking about what I would do different the second time around, we'd probably try to settle this thing out right off the bat and just say, okay, we violated calling you in the do-not-call list. If it's one or two calls, even if we had their opt-in, their lead registration form, we could easily say, you register. We could do that. Or we could decide in that moment who we're really dealing with and say, is it better just to offer them something and have them go away? I mean, you have to make that choice in the moment, but work with your attorney and figure that out, because we could have maybe diffused this. But we stuck to the fact that, we've got this lead registration form. We know we have it. We're not going to pay anything. And, then she got upset and went and got an attorney and tried to get the whole class action. So you have to make those choices. What's best for you and your company. And that's only between you and your attorney, of course. But I think the way you handle it from day one could have an impact on how it wraps up too.
100%. I couldn't agree more. I mean, it's better to attack the problem head on than just put your head in the sand and pretend it goes away, because it often doesn't.
Correct. So Phil, do you have that cheat sheet you can put in there? And if you want, throw your number in there too. You've dealt with this kind of case before. Correct me if I'm wrong, but this is a national thing. They can hire an attorney based out of any state, right? I mean, it's something that it's a national law, right? Is that correct?
And just a little bit of my background is that, we have a national class action practice. Whether whatever state you're in, we're happy to help. We probably associate with the Logan Council in some instances, but look, it's a federal law. It applies, generally speaking, the same in every state. So we're happy to help however we can. I'll put my information in the chat panel right here. I think I also spoke with Sandra about uploading a little cheat sheet as well. And we'll get the ball rolling, but I'll put in my contact information right now. And if anybody has any follow-up questions, whether it's today, tomorrow, 3 months from now, whatever it is, like I said, you have my cell phone. You can reach me by phone or text, whatever's best for you. We truly are here to help, and we want to prevent this thing from happening. It was hard to see a company like Mike's go through this process. It was painful. We're happy that they had a happy ending, but that doesn't always happen. So we want to kind of spread awareness now and fix it head on. So you save money on fees and you don't end up paying $40 million like Keller Williams.
So do you want to go ahead and throw your number in the chat there, Phil?
I am. Yep.
Why don't we do that real quick? And again, not trying to sell Phil's service or anything here, but not everybody does these types of cases. Just figured if you guys need this type of work or consultation, Phil's been a good guy to work with.
I appreciate the heads up, Mike. Is there a way for me to upload this cheat sheet?
Yeah, what we'll do is if you work with Sandra, she can attach it to this webinar when it posts. That way, whoever wants it can grab it from there. So Sandra can get that for you.
Great. Well, I appreciate that. And my number and my email, my cell phone number and my email are in the chat. Let me just see. Okay, it's there. Thank you, Jake, for doing that. Like I said, anybody wants to chat at any time. We operate pretty much around the clock, so we're always happy to chat whatever time it is. If it's 2 a.m, we may not pick up. We'll call back at 6:30. How about that?
Nice. All right. Well, I'll tell you what, Phil. Thank you guys all for attending today. Hope you guys got some value out of it. Hopefully, you will never ever need to deal with this issue. But if you do, there's good ways to do it, and there's better ways to do it. And there's terrible ways to do it. So I always make sure you're getting some help with that. Thanks, Phil. We'll catch you on the next one.
Hey, thank you very much, Mike. Thank you, Jake. It's very nice to speak with you all today. All right. Thank you.
See ya.